Hi, this is Fredrick Niemann of Niemann, a central New Jersey law firm practicing estate planning and succession business planning in all 21 counties of the state of New Jersey. Perhaps you're a successful businessman or businesswoman and have spent decades creating, building, and growing your business. It's very successful, and you want it to continue being successful into the future. How do you make sure that you can protect it going out into the future? The answer is plan now for succession planning. Succession planning helps you handpick your successor, the person who or persons who will operate and run your company going into the future. A well-written succession plan will define the terms, the conditions, and the financial details of your withdrawal. A well-written succession plan as part of New Jersey estate planning will secure the performance of your financial objectives going into the future by mandating certain benchmarks to be met or exceeded as a condition of your giving up ownership and control of the business. A well-written succession agreement also thinks out into the future in case the succession plan doesn't work out. How you can regain possession of your business and resume its profitable direction and make sure that it is not run into the ground or even worse, put into bankruptcy. All of these provisions need to be put into a succession agreement. In the absence of a well-written plan, you're at the mercy of the key employee that you sell the business to, or perhaps your son or your daughter or other family members. Just because your son or daughter is next in line to take over the business doesn't immunize you from risk. Truth be told, in their minds, your son or daughter are entitled to the business. It's not that they have bought it from you, you're giving it to them. And once they take over, they may forget or conveniently omit the fact that they're responsible for buying you out so that you have adequate income in your retirement. Remember this, a well-written succession plan will cover your future participation, if any, in the ongoing management and operation of the business. It'll talk about retirement under what circumstances you choose to exit from the business. It'll talk about what happens if you're disabled, you have a heart attack, stroke, or other incident causes you to be unable to perform the activities of your daily job. It'll also address such circumstances as death. How will the business continue? What will be done with the proceeds of the business? How will the new buyers buy out your estate? Those provisions are often put into a succession agreement. And what about your other children? What about those children who are not involved in the operation of the business? How will you address that? Because that could be the source of much conflict long after you're gone or in the course of your retirement. And your spouse. Is your spouse a key person in the operation of your business? Is it someone who you want to continue, or do you want her interest bought out? Remember, if you have other partners or shareholders in your business and something happens to them, or they choose to retire or become disabled or die, do you want to be in business with or partnership with their sons? And how will they treat your family members or your spouse under the terms of the operating agreements or shareholders agreements? Those kinds of considerations need to be put in a well-written succession plan, shareholder agreement, and operating agreement. You can protect your business. You can protect it through a well-written succession planning document. Call me today. Call me toll-free at 888-800-7442, or you can email me at fniemann, Niemann, at hnlawfirm.com. We'll sit down, we'll talk about what's important to you. I have a lot of practical business experience in addition to being an attorney, and I look forward to meeting with you real soon.